Let's see what the law requires for someone to take office who wants to be a judge or public servant. California Constitution, Article 20, Section 3. It says members of the legislature and all public officers and employees, executive, legislative, and judicial, shall accept such inferior officers and employees as may be by law exempt, shall before they enter upon the duties of their respective offices take and subscribe the following oath or affirmation. What does subscribe mean? Subscribe in a legal context means the action of writing one's name on a document in acknowledgement of being its creator. For example, subscribe a letter, signing a document to give one's consent to the terms established therein. For example, subscribe a contract. So the oath of office is a contract, and I did a public records request for David Gottlieb. Here's a copy of his oath of office. That reads, I, David Gottlieb, do solemnly swear or affirm that I will support and defend the Constitution of the United States and the Constitution of the State of California against all enemies, foreign and domestic, that I will bear true faith and allegiance to the Constitution of the United States and the Constitution of the State of California, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well faithfully discharge the duties upon which I am about to enter. David, signature of the presiding judge at the time. Now, the subscribing of their oath of office is a contract that the person signing it is in agreement, swearing to support the Constitution. It is the contract that they are bound by to work for the people, or they can't work for us. It literally puts them in a box and says, you must abide by these boundaries that are declared in the Constitution called constitutional provisions, and you cannot go outside of the limits of this box. They also raise their right hand and swear with their mouth, knowingly, willingly, and intelligently declare the same. So if they do anything that there's no constitutional provision granting them the authority to do, then they are knowingly acting without authority to cause us harm, because they know they are not supporting the Constitution that they swore and signed willingly that they would. Now, the California Constitution, Article 1, Section 26 says the provisions of this Constitution are mandatory. Now we go to the Mason's Manual of Legislative Procedure. That's what the legislators use to create, the statutes and to law they have to go by. This is their procedures they have to follow. They too know that they have to follow constitutional provisions. And in Chapter 2, Constitutional Provisions Governing Procedure, it says in Section 7, constitutional requirements concerning procedure must be complied with. It says, being organic in character, constitutional provisions stand on a higher plane than statutes and are mandatory. So they know the Constitution says it, the legislature says it, that the constitutional provisions are mandatory. So that's page 17 of the Mason's Manual of Legislative Procedure, which I will put a link to it in the description. So that makes it really simple for any of us to check anyone in government to see if they are acting outside of their authority. All you have to do is ask them a simple question. Show me the constitutional provision granting your authority to use like penal code against the people in the private. Remember, you are in the private. You can just type something out like this and serve them, or you can ask them. And when they can't show you the constitutional provision granting their authority to do what they are doing or saying, then they don't have the authority and they are liable to both civil and criminal prosecution and removed from their job. Now, they will try and say that they have something called immunity from prosecution, and that's partially true. They have immunity when they are acting inside the box of their authority and they did something on accident. Then they have immunity. But when they know they are doing you wrong, they are acting intentionally and they lose all immunity. And the judges and the district attorneys know what they can and can't do. And when you catch them and ask them to show the constitutional provision granting their authority, and if they don't stop right there and check if they have the authority and don't show you that they have the authority and continue to proceed without finding out if they have the authority, then they are liable to civil and criminal prosecution, and you can take their house and all their money because they are now acting knowingly because you gave them time to do their research and find out if they have the lawful authority. And they don't, and they know they have to find out because you just gave them notice by challenging their authority. You just challenged their jurisdiction, and everything has to stop because they can't cause you harm. And when they don't have the constitutional provision granting their authority to do something, then they lose all immunity and subject to civil and criminal prosecution because they can't cause we the people harm because they work for us. You could do a simple public records request and see where they live. I mean, I'm just saying, like, I like nice houses. And I can see if my new toys are going to fit in the house and their house when I take it from them. They are public servants, and all their information is of public record. How much money they make to their home address and how many homes they own. It starts to become real simple when you know who you are and how simple the law is that protects you from them. Now, they won't tell you this truth, and they will do everything they can to stop you. And the courts are full of attorneys. They are all members of the same club called the Bar Association. The judges, the district attorneys, and attorneys are all members of the same club and working against you so you can't win. They rig the courts to be in their favor. And some might call that treason. Our form of government was designed to protect us from this exact thing. That's what the Constitution does. But Bar Association members have hijacked our government. They changed it unlawfully from the common law to statutes and codes that don't apply to us. It applies to corporations and to those in government. And that's all explained in the criminal complaint video that I put in the description. And I'll give you, this is California Code of Civil Procedure, miscellaneous provisions, the kind of degrees of evidence, Article 2, public writings. Statutes are public or private. A private statute is one which concerns only certain designated individuals and affects only their private rights. Right? So that's the people in the private. So private statute only affects our private rights. All other statutes are public, in which are included statutes creating and affecting corporations. So when they come at you with a statute, how is that protecting your right? It's not. They're using a statute that only affects corporations. What's a corporate servant? It says, as used in Article 6, corporate servant shall mean any natural person who is or was a director, office, employee, or agent of the corporation, or is or was serving at the request of the corporation as a director, officer, manager, partner, trustee, employee, agent, other foreign or domestic corporation. So how does public statutes affect you? Well, they don't apply. Well, they can't make money off of us if we know this, and will try and intimidate you if you speak up and challenge them. That's why they don't want you talking. They try and put fear into you so you won't speak and have it on the record. And they have the bailiff there to try and shut you up. And then now he's liable because he swore an oath too. Isn't that literally internal insurrection? Are they overthrowing our form of government, which is the Constitution, and warring against we the people when they knowingly go outside of their box? Isn't that treason? Well, you decide. Now I went before David in September of 2022, where I made it clear to David that I established the fact that there's no constitutional provision granting anyone the authority to use penal code against the people in the private. Penal code is a form of statute. So what are we doing here? And David never said that I was wrong or never tried to rebut my claims. David said there was a trial as to an issue of my competency and that I was found not competent. And David knows that, one, I was never evaluated by any doctor, so I don't know how anyone came to such a conclusion. Two, that there was no lawful trial. And three, the whole competency scam is not constitutional. It's not lawful. And David knows that constitutional provisions are mandatory and above statutes, and that he has to follow the law, and the law is the Constitution. I further asked David to show me the constitutional provision granting someone the authority to even have an evaluation done. And David said, no, it's not my job to educate you on the law. So David right there knew that there's no law, that there's no constitutional provision granting anyone the authority to have me evaluated. And that would have ended the whole evaluation narrative. But he intentionally refused to answer me so that he, along with the district attorneys, can try and say that I was mentally incompetent. And I believe it was to try and discredit me because I'm exposing that they are committing fraud on the people with fraudulent criminal complaints right in front of the sheriff's deputies every day. There was like 6 bailiffs standing in the court doorway that day listening. So I told David that they are wondering what's really going on because they hear me, and I believe that they believe that I am competent to the point that one of the bailiffs, Kyle Nemeth, testified that I am competent at a fake trial. And one of the attorneys about flipped her wig because she didn't expect him to say I was competent. The only witness that actually had a meaningful conversation with me testified to me being competent, and the doctor who I never had an evaluation with said I was incompetent. Now, how do you think she came to that conclusion? That's fraud. And so the bailiffs needed clarification, and David said, you already did that, Mr. Martinez. Now, I beat that case that I'm talking about, and I never accepted the help of an attorney, and I made a video of David, and I put a link to it in the description. And I will be making a series of videos exposing him as I gave him the opportunity to do the right thing and turn from his wicked ways, and now I have to expose him. Let's take a listen to what David and I had to say that day.
I am accountable to the people, and I appreciate you bringing that forward. We are an open court. It's open to the public.
Yes.
Anybody can hear and see what we're doing.
So for the record, then, you understand that there is no constitutional provision granting anyone the authority to use penal code against the people in the private, and the competency hearing is based off of penal code, so that really doesn't apply to the people in private. For the bailiffs, the bailiffs would like to understand. I think they're a little bit worried about what's really going on here.
I'm not going to address that here today because that's not my calendar today. And so what I'm going to do is I'm going to just reiterate my orders that I've already made, and that is that you need to return here on the 18th at 1:30.
Okay, well, I'm just making it clear for the bailiffs, because the bailiffs want to.
You've already done that.
They want to know.
You've already done that.
Correct, this is what you're saying. For the record.
You already made the record. All right, thank you, sir.
Now, if the sheriffs would only pay attention to the fact that everything I've said, I have proved, and not once has anyone tried to prove me wrong. Not once has any judge or district attorney or attorney said, look, Mr. Martinez, the California or United States Constitution, Article 1, Section 1, says right here that we can make a criminal complaint that reads, we represent the people of the state of California, without actually representing any of the people. And right here, it allows us to lie and declare that we personally appeared before a deputy clerk, first being duly sworn, and that what we are saying in this document is true. And we don't actually have to swear under oath, and we don't actually have to swear the complaint in before a magistrate. We can just say that we did it before the deputy clerk and get the clerk with no lawful authority to sign it as if the document is actually a true sworn legal document. This is the constitutional provision that grants us the authority to lie and make what would normally be a fraudulent document and file it. And if you look right here, Mr. Martinez, this constitutional provision grants us the authority to use statutes, penal code, that is for creating and affecting corporations. The government. We can use it against the people and the private. Yeah, I see that the California Code says that there is a public and private statutes, and that private statutes are only for protecting your rights, Mr. Martinez, and that public statutes are for creating and affecting corporations. You are absolutely correct. But this constitutional private provision right here, Mr. Martinez, allows us to use whatever statute we want against the people and the private. So now that you understand, and I've been answerable to the people, to be transparent as declared in the Constitution, that I am at all times answerable to the people, and I have proven my authority to make this criminal complaint in this manner and use statutes that don't apply to you. How do you wish to proceed, Mr. Martinez? If they actually did that, this would change everything. This would prove that they have the lawful authority. But for some reason, the sheriff deputies want to turn a blind eye and say, I'm just doing my job. And some of the sheriff's deputies actually want to see me fail. They want to hurt me. And all I'm doing is exposing the fraud being done to the actual people they swore, so help me God, they will protect. I'm proving it right in front of their eyes. Now, not all deputies are bad. They're all just improperly trained and have been lied to. We all have been lied to by these people. But I'm proving by God that the judges and attorneys are committing fraud on the people they swore to protect. And one day, one of them will realize who she is and do something with all this evidence I'm showing. Now, I filed a notice that I was going to record the court proceedings, and David made it his wish to come before me on March 12th, 2025, in another matter. And David asked, what was my reason for wanting to record? Let's take a listen.
So typically, pursuant to 1.150 of the California Rules of Court, this court typically does not allow for photography, recording, or broadcasting of what goes on in court. What is the purpose for recording the matters that are being heard in this court?
Well, for one, it's a constitutionally protected right. Two, you can buy the audio recording for $70. And that just doesn't, if you have the constitutionally protected right to do it, why would you pay $70 for something? And then it's cut up. I've purchased several copies, and they're cut up, and it's missing words, what either the judge is saying or the district attorney is saying, or what I'm saying, it gets cut up, so you can't get the full thing. And so as me being part of the media, I want to expose what's happening in the court case, as well as helping me prepare for trial.
All right.
And I can't do that when it's cut up, because there's a lot of stuff cut up, and there's mics cut off sometimes.
All right. The court's going to deny the request at this point in time without prejudice. I'll allow you to re-raise that issue again. I want a declaration, though. There is no declaration attached to this. And so I would want a declaration, and also if you feel that the fee is, you're unable to pay the fee, please list the circumstances as to why you can't afford it. And so I'll consider that at the next hearing, but for today's hearing, the court's going to abide by California Rules of Court 1.150 sub C. All right.
So I don't understand what that court...
Sir, I made a ruling.
We're done with that. We're done with that.
We're going to move on. We're going to move on.
Well, I do have the right for you to
I told you not to interrupt me.
Well,
if you
you're
continue
cutting
to do
me
that,
off, sir.
you're going to be leaving the courtroom.
Okay, I'm just trying to get your lawful reason. That's
I made the ruling.
So that's it.
That's it.
I'm supposed to accept that?
Yes.
So I think you're being biased, and I think you should recuse yourself then.
Okay, I think you're going to be escorted out of the court. Thank you, sir.
Okay.
Your Honor, may we move orally to continue the jury trial? I have thoughts in the handling DBA case before.
Can I get my copy of my abstract? Okay, so about it. Okay.
No. Wait. I have one other thing that's going to happen here. Based upon my review of the file and based upon Mr. Martinez's actions here in court today, the court is going to suspend proceedings and appoint K&L to do a determination as to whether or not Mr. Martinez is competent to represent himself. I know that they have found him competent to stand trial. However, pursuant to the Edwards case, as well as the case of People versus Shiga at 6 Calap 5th 22, and I'll cite the Edwards case as well. so that we have that on the record.
Sir, are you proceeding with private or?
Okay, it's Edwards at 554 U.S. at page 178. And I'm sorry, sir, you had a question?
Yes, are you proceeding with private or public statutes?
I read off what I already read. So
No, I get that, but I don't know what that is. Is that a?
I made the ruling, sir.
Are you proceeding with private?
You're
or public
representing
statute?
yourself, sir. I can't tell you the law.
Well, I know, but if you're using public statutes, well, your California code says private statutes is one which concerns only certain designated individuals and affects only their private rights. All other statutes are public, in which are included statutes creating or affecting corporations. And I'm not a corporation, nor do I work for the government. So if you're using public statutes, this case is over.
Yes.
Sure.
Yes. Yes.
And then to go further, American jurisprudence also says that statutes, by contrast, are enactments and rules for the government. So there you go. I'm not a corporation, nor do I work for government. So if you're using public statutes, then this case is over.
Yes, but that is a yes.
There's no personal jurisdiction for the record.
November 13th? Yes, so Thursday the 19th. 9 o'clock on the 19th. Okay, I'll call you back with more information, okay? Thank you.
Mr. Breezy, do we have a timeout?
Your Honor, I believe it's in general time waiver status.
Okay. All right, that's fine. All right, so, sir, the court's going to order that you return to this court on March the 19th, in order to be interviewed for further determinations as to whether or not it's appropriate for you to continue to represent yourself. So you're ordered to return back on March the 19th at 8:30 in the morning for that purpose, and also for setting of your trial. The court's going to vacate the currently scheduled trial date.
So for the record, I'm going to need a signed court order by you for that.
I've made my rulings.
That's fine, but I still need a signed court order
I've
for it,
made my rulings.
for it to be lawful. I'm not going to do it unless you get a signed court order. So
We'll give you a copy of the minute order if
No, that's not a court order, and you know that. There's a
Sorry,
difference.
sir. I've made my ruling.
That's fine, you made your
You're
ruling.
ordered to be here on that next date.
Okay, I need a signed court order.
We're
Signed
done.
by a judge.
We're done. Thank you.
So you know that, so it's not a lawful court order then.
Now, I don't have to give a reason. It's a constitutionally protected right, but I gave good reasons. As you can see here, California Constitution, Article 1, Section 2. Every person may freely speak, write, and publish his or her sentiments on all subjects, being responsible for the abuse of that right. A law may not restrain or abridge liberty of speech or the press. The United States Constitution also, it's the same thing. David is sitting here talking about that he's ruling his decision was off of this, which is California photographing, recording, and broadcasting in court. And he denied it, my notice to record, because it says, except as provided in this rule, court proceedings may not be photographed, recorded, or broadcast. Okay, but then you go down to media, like I told him, I'm part of the media, right? The California Constitution protects that right. It says media coverage may be permitted only on written order of the judge as provided in this subdivision. The judge in his or her discretion may permit, refuse, limit, or terminate media coverage. Okay, then they throw this in there, which is the important part. This rule does not otherwise limit or restrict the right of the media to cover and report court proceedings. Why does this rule not restrict the right of the media? A law may not restrain or abridge the liberty of the speech or the press. Now, I gave him some pretty good reasons. Now, I have other reasons as well. I had when I got the copies of CDs of the audio recordings, which cost $70 for a copy of the CD. The files have been corrupted. Like I literally got one that was corrupted. I got one where they missed part of the audio, so that gives me more standing as the recording of the CDs. It's missing part of the proceeding. Let's take a listen when I called them and talked to them about it.
Please listen carefully, as our menu selections have recently changed. For jury, press 1. For traffic matters, press 2. For other court matters, press 3. For general information such as hours of operation. For criminal, press 1. For civil, press 2. For family law, press 3. For juvenile, press 4. For miscellaneous court operations, press 5. For probate, press 7. And for all administrative services, press 8. You have reached the Fresno Superior Court Administrative Division. For the Administrative Office, press 1. For the Facilities Department, press 2. For Human Resources, press 3. Or for the court to... Fresno Superior Court Administration, this is Amanda.
Yes, I was calling to find out, is this the section that does the CD recording of the court proceedings?
Yes.
Okay, so on the 19th, I had a court hearing, and then I filed on the 19th also to have a CD recorded. My name is Gabriel Martinez, and you guys just did it last week? Or, this on Wednesday, I think it was, or something like that. Okay, so when I got the CD, it's missing about 3 to 5 minutes of the last part of the proceeding.
It's missing?
Yeah, like it was cut off and it stopped. And there was still conversation between the judge and I. Continued on for about 3 to 5 minutes of that. And it's missing that whole section.
Okay, hold on.
Okay, so that conversation went on for a little while. And she did some research on it to find out if the actual recording was messed up or maybe she missed something. And she did. She called me back and apologized. She made an error. Let's listen to the recording.
Good afternoon. This message is for Mr. Martinez. My name is the Fresno Superior Court. I was just calling to let you know that we have prepared another CD for you. That was an error on my part, but we will be mailing you out a new one on Tuesday. If you have any questions, please give me a call. My number here is 559.
Okay, so we understand it. There's another good reason why I should be able to record the proceedings, right? I can't get a copy of the CD from the court for that simple fact. There's problems. I also have a recording of the CD that they sent me that was corrupted. All right, so we get the picture. So I gave good reasons, but when I said I was going to expose this, David decided to trespass on that right. And David refused to cite a lawful reason, and now he wants to have me evaluated. And I asked David to give me a copy of a court order. David said he'll give me a minute order. But as you can see here on the Superior Court's website here, it says a minute order from the hearing may contain the decisions in your case, but it's not the order because it's not signed by the judge. And let's see. Right? Minute order from the hearing may contain the decisions in your case, but it's not the order because it's not signed by the judge. Now we also have from American Jurisprudence, which is their law book. It reads, a general rule, an order of a court becomes effective only when reduced to writing, signed by the judge, and filed with the clerk for journalization. A written order may be required to conform strictly to the court's decision. However, as a general rule, no findings are required to support an order pursuant to a motion unless required by a statute. Let's see. And we also have here from the Court of Appeals, they say it as well. Any order of a court becomes effective only when reduced to writing, signed by the judge, and filed with the clerk for journalization. You got attorneys that tell you, when does a judge ruling become a valid one? This guy says, as South Carolina Rule of Civil Procedure notes, a judgment is effective only when so set forth and entered into the record. In 2006, I actually went to the South Carolina Supreme Court on that issue, which resulting in an opinion that an order wasn't valid until it was signed by the judge and filed with the clerk's office. And we got North Carolina's General Assembly. It says a judgment is entered when it is reduced to writing, signed by the judge, and filed with the clerk of court pursuant to Rule 5. Now let's take a look at what court orders actually look like. Here's the main standing order, filed, signed by a judge. It's another standing order, filed, signed by a judge. Order, directing commissioner, presiding judge. There's just a list of just orders, just from one case, but you get what I'm showing you here, that a court order signed by a judge and filed with the clerk. Here's one from Texas. An order. This was done in 2023. You can just do a Google search for a court order, and it shows you what an order looks like and the signature from the judge. Now, David is trying to have me evaluated, try and cover up the judges and district attorneys' fraud that they've been doing on the people with fraudulent criminal complaints and statutes and penal code that don't apply to us. I made a video proving the criminal complaint is a fraud, and a link to the video is in the description. Now, on April 1st, 2025, David and the district attorneys were served with something called a quo warranto, which is a common law writ requiring someone to show by what authority they have. The people at the clerk's office have been interfering with me filing documents to stop me from having my documents shown on the public record so that I can show the world the fraud that's going on and to have my documents heard in open court. I made a video of that and put a link to it in the description, where you can hear a man named Robert Mangano, who claims to be a judge, who does not have an oath of office on file with the clerk's office, say my subpoena and documents are not filed in the record when I clearly have copies of them with file stamped on them from the clerk's office. And he says that we can't discuss having an actual arraignment where I subpoenaed the district attorney, Bethany Samarin, and Matthew Hamilton to show the constitutional provision granting their authority to create a fraudulent criminal complaint and make them swear under oath to their claims. We call that due process. After the video of the clerk admitting she was told to commit fraud, well, she didn't say fraud, but she was told to not file them, they started filing my documents and putting it on the public record. And now David is trying to prevent me from exposing the truth. So I served David and the district attorneys the quo warranto, and they had 3 days to respond and show their authority. They all failed to answer, and since the document is now filed and on the public record, David and the district attorneys have to answer on the record in open court. And if they fail to answer and show their authority, the world will know they do not have the authority. This is more evidence for prosecution. And these cases against me have to be discharged. And that would be part 2 of this video. Let's take a look at what they were served and have to answer. And you will see why they've been fighting so hard to try and stop me, and why they want to discredit me and say that I'm mentally incompetent so that I can't take it to trial and expose the truth to the jury. So they got served this document just like this. It was on a cardstock piece of paper. I put the certified mail on top, got it stamped, a stamp for it, and mailed them the document. I made copies of it, so you can look up the certified mail number and you'll see that they received it. And when they received it, his office put it on the public record. So let's read it. This comes now, Affiant Gabriel Joe Martinez, a man in the image of Yahweh, one of the people in the private of the 50 American states. Republican inform is because we're guaranteed a Republican form of government. Sui juris in this court of record do bring the following claims and facts that you may take notice and provide due care. My claim, right off the back, I claim there's no constitutional provision granting anyone the authority to use statutes or code against the people in the private. Now, I ask them, by what authority, which the constitutional provision, do you or anyone have to use penal code, statutes, against the people in the private? Number 2, alter our common law courts of record to statutory courts and use them against us. Number 3, to support your beliefs, to say you do not agree that a minute order is not a court order. I just showed you guys clearly a minute order is not a court order. And that an order of a court does not become effective only when reduced to writing, signed by the judge, and filed with the clerk for journalization. Number 4, ask me to perform an evaluation. 5, interfere with my right to be heard and make the record. 6, trespass upon my right to record the proceedings. 7, use fraudulent criminal complaints against the people in the private like you were doing. 8, trespass on due process. So California Constitution, Article 1, Section 26. The provisions of this Constitution are mandatory and prohibitory unless by express words they are declared to be otherwise. Please take notice of the Legislature's Handbook to Create Law and Statutes. Mason's Manual of Legislative Procedure, page 17, Section 7. Constitutional provisions stand on a higher plane than statutes and are mandatory. So I'm citing the law here and where I'm getting my beliefs and my proof, my evidence. It says, please take notice of the New Hampshire House Bill 1778. Further, the courts have found that corporate public servants who ignore their accountability as mandated in Article 8 of the New Hampshire Bill of Rights have, by their silence and failure to fully inform the sovereign people of the consequences arising from corporate offer to contract, is deemed silent deception and inducement by fraud. So by their failure to not tell you the truth and getting you to contract with them, is deemed silent deception and inducement by fraud. Now right here, please take notice that I am not a corporation, nor do I work for the government. Compare my facts with your beliefs below. And I showed you that earlier. California Code says statutes are public or private. A private statute is one which concerns only certain designated individuals and affects only their private rights. All other statutes are public, in which are including statutes creating or affecting corporations. Then we have 16 American jurisprudence. Constitutional law. Distinctions between constitutions and statutes. Statutes, by contrast, are enactments and rules for the government. As an expression of the will of the people, a state constitution stands above legislative or judge-made law. Please take notice that a minute order is not a court order and that a lawful court order must be signed by the judge and recorded by the clerk. Then I compare that with American jurisprudence, which I showed you. As a general rule, an order of a court becomes effective only when reduced to writing, signed by the judge, and filed with the clerk for journalization. And then compare that with the Superior Court of California, County Imperial. A minute order from the hearing may contain the decisions in your case, but it is not the order because it is not signed by the judge. Please take notice that your actions, internal insurrection, is overthrowing the Constitution, government, and war against the people, and an unrebutted affidavit stands as truth. You could compare that with Wood versus Berry, 3rd District Court of Appeals of California, February 11th, 1931. It reads, the charge of bad faith against Berry is overborne by the affidavit of merits. That affidavit stands unchallenged and must be accepted as true. Then put Luke 11:52. Woe to you lawyers, for you have taken away the key of knowledge. Now here we go. If you deny these claims are true, you must rebut them within 3 days of receiving this quo warranto, point by point, with constitutional authority, under the penalty of perjury in the form of a sworn affidavit. Failure to rebut means that you agree that you are knowingly attacking the people with full intent, malice, and ignoring your oath to protect all rights you swore to support and defend secured in the California Constitution. Failure to respond means that by acquiescence, you agree that all claims are true and that this affidavit may be used against you as evidence. I pray that this quo warranto finds you in peace, and I send it in the love of God by Jesus Christ, and hope that you will find the will to correct these issues with the people, so that we shall dwell in liberty and you may stand honestly in your dealings with those you are hired to serve. And here's the verification, sworn under the penalty of perjury before an officer of the court. This is a sworn affidavit, and as we just read right here, that an unrebutted affidavit stands as truth, and they have not rebutted it. Same thing was mailed to the office of the district attorney. And we will continue this in part 2. We'll see how they answer this in court.